and do my spiel. Hello, everyone. Today is Tuesday, January 17th of 2023, and we are convening a session of the Tax Review Board. My name is Melissa Andre. I'm the Executive Director, and I have to say that everybody please be aware that this is a public hearing and it is being recorded because the meeting is public. Participants and viewers have no expectation of privacy. And by continuing to be in this meeting, you are consenting to being recorded. This recording will be posted on the Tax Review Board website. With us today is Nancy Kamerdiener, our chair, as well as board members Paula Weiss, Dominique Ward, and George Matthews. Nancy, please take it away.
Okay, fine. Thank you very much. Good afternoon, everyone. The first item on our agenda is a decision only for Joseph Weisswasser. I understand that his daughter, Susan, is in our room or on video. I'm not sure which way it is. Please identify yourself for the record.
I'm here, Susan Weisswasser.
Okay. At this point, I think we're only providing the decision, but you may be called upon to make some other comments, and therefore I am going to swear you in. Do you, excuse me, do you swear to tell the truth with everything that comes before the board?
I do.
Okay, fine. Thank you very much. The board has reviewed this matter, and it's our decision to deny the matter as the usage indicated a leak and high usage. I don't know whether any of the other board members have anything to add to that decision. I'll give them an opportunity to speak before we turn back to the petitioner's rep.
No, Nancy, this is Paula Weiss. I concur with that decision.
Dominique Ward, I concur with that decision as well.
George Matthews, I concur with that decision too.
Okay, fine. And obviously, having stated it, I concur with that decision. Are there any questions from the petitioner's representative?
I think this is the first time that anyone's mentioned.
Can you speak up a little bit more?
I said, I think this is the first time anyone's mentioned a leak. You said there was a leak. No one's talked about a leak before. I'm wondering how you came to that determination.
Does anyone have anything to add on that score?
Ms. Weisswasser, we reviewed all the evidence and testimony presented at the hearing when we took it under advisement. And based on all of that information, our information led us to that conclusion after reviewing both the paperwork and the testimony.
You'll get a letter from us that spells out our decision. Both sides have the right to appeal to the Court of Common Pleas if they so choose. And failing that, then if there are any amounts due and owing after that, you should work with the city water department and or the Water Revenue Bureau to enter into any final payments if those are outstanding.
How long do we have to take an appeal?
30 days.
30 days from the date
sorry.
of the letter or from the
30
date
days
of the
from the
letter?
date our letter is postmarked to you. And I remember we updated your address. So 30 days from the date of the letter that we sent to you with
Okay.
our decision. And then you'll have 30 days from the date the water department, from the water department to make an agreement with them. If you just want.
Okay, I have been having a problem, my building has been having a problem with our mail. Is there any chance that I can get a copy by fax or by email?
After the person who handles this category, I can email it to you because I know we've corresponded before. We're
Yes,
still
you have
gonna
my
send it by
email.
mail though.
Okay, that's fine. I
All
just want to make sure I get it.
Absolutely.
Thank you for joining us today.
Thank you.
Okay. All right, Mr. Hold on one more second.
Not with that. Can you say something?
Hello, testing.
Does everybody hear him?
Yes.
All right. Nancy, Mr. Horton is in the room.
Okay, fine. Thank you very much. Good afternoon.
Thank you. Good afternoon.
This item is docket ending in 2358 for Troy Horton. Please identify yourself for the record.
I am Troy Horton.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes, I do.
We've had this matter before us before. I guess really I ask if we could identify who the city's representative is and then see where we go from there. Who is the city's representative in this matter?
If the board pleases, this is Kareem Saifinine as counsel, and I have as witnesses today Chanel Smith for water revenue and Paul Parker as custodian of records and an expert witness on water meters.
Okay. If we could have them identify themselves for the record, please.
Yes, I'm Paul Parker from the meter shop. I'm
Chanel
the
Smith.
supervisor in the meter shop.
And there's one more?
Okay, Chanel Smith, witness for the city, Water Revenue Bureau.
Okay. In each case, do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Yes, I do.
Okay. Thank you very much. Do you have any opening comments from the city before we turn to the petitioner?
Yes,
You know,
if I-
Nancy, could I interrupt a second? I think what would probably be helpful, since this is a remand from the Court of Common Pleas, I think I'd like to ask Ms. Andre, our executive director, to just give us a brief recap of what that remand order directs all of us to focus on.
Correct.
That's probably a good idea. I was going to look for that next, but I think upfront is probably better.
Hello, everyone. I think everyone is aware of what the court order is saying, but I'm going to read it just for the record so we can focus our testimony and questioning to what the Court of Common Pleas has asked the Tax Review Board to review and make a determination. And this is from the order dated November of 2021, I believe, actually.
Yes,
December
2021.
22nd of 2021. And I'm going to start from the court's review of the certified administrative record, and after oral argument, it is ordered that this matter be remanded to the Tax Review Board for further administrative proceedings. Specifically, the Tax Review Board shall hear testimony and or evidence on the following issues. 1, whether the water meter at issue was improperly installed. 2, if the water meter was improperly installed, the impact the improper installation had, if any, on the meter reading that established the water usage at issue. And 3, if the water meter was improperly installed and the subsequent meter readings were inaccurate as a result of the improper installation, whether the Water Revenue Bureau is permitted to estimate water usage, and if so, the result of those estimates in water usage and dollars. So let us focus our testimony and evidence on this particular issue and proceed.
I'm sorry, may I just ask that the additional order, portion of the order be read into the record as well? I think that is relevant.
Where is that?
That's on the second page. It said it is further ordered that the Tax Review Board shall issue either a new decision if different from its original decision or supplement its prior findings of fact and conclusions of law.
Absolutely, Mr. Horton. I'm sorry about that. Thank you.
No problem. I have a brief housekeeping matter before we proceed.
Please go ahead.
I would ask that the the city's witnesses be sequestered in this matter in the form of muting the non-testifying witness until it is time for them to testify. That will ensure the integrity of these proceedings. I think it's appropriate at this time.
Well, their request was already made at the beginning of the hearing that anyone that's not speaking be muted, but
I wasn't here for that. I was actually directed to go to another room. I was there waiting for a couple of minutes.
well, no, when you were actually in the room, she actually is already, she said that as well.
My apologies, I didn't hear it. I was trying to set up.
Mhm.
But
So,
we agree. Anyone who is not supposed to be testifying, they should be muted.
And just a request for you, and this is directed to the petitioner, that ask that you speak as clearly as you can, as close to the microphone as you can be. The microphone is in front of you near the computer, just so that we can all hear you clearly and distinctly. Okay.
I'm sorry, Madam Chair, did you say Mrs. Drake?
I'm having trouble hearing you occasionally, and I am asking that you be as close to the mic as you can so that we
Oh,
hear you
okay.
clearly and distinctly.
Testing, how is that?
That's better than it was before. Thank you.
Thank you very much.
Okay. Let's see, where were we? I think I was about to call for opening comments from the city, if there were any.
Yes. As Melissa stated, this is a remand from the Court of Common Pleas. And in support of that, the parties are agreed. We have discussed before that the record from the prior hearing does remain in effect. So this is supplementary testimony, not a replacement. That being said, because two of the board's members at the time of the prior hearing in 2020, specifically Mr. Piccirilli and Mr. Furla, have been replaced by Ms. Ward and Ms. Weiss respectively, I think it would be reasonable for us to both restate briefly what our cases are, how our views of the issue at hand. So from the city's perspective,
Can I interrupt a moment? I just want to state, this is Paul Weiss. I was here for the first hearing.
were you?
I was.
Oh, okay. My apologies.
Mr. Piccirilli was also here and he is no longer on the board. That's correct, but I do have experience and recollection.
Okay, my apologies. I got confused.
Okay.
Thank you. Because from the city's perspective, this is a straightforward back bill on actual reading after meter work discovered that the transmitter portion of the encoder register transmitter ERT unit was stuck on its initial reading. According to meter shop records, a meter shop technician gained access to the property on October 30th, 2017, and found that the visual reading shown on the mechanical dial portion or register portion of the ERT was higher than the reading being sent electronically from the transmitter portion of the ERT. Further reviewed that the confirmed that the reading that the transmitter was sending or was stuck on, in Mr. Parker's terminology, was the reading to which it had been set when it was installed on July 31st, 2010. There was no, suggestion at that time that anything was wrong with the mechanical meter body or with the dial, according to the meter shop records. There was a photograph which was submitted, which will be the subject of examination in this hearing. Now, as just to round out the city's position, as Mr. Parker testified at the previous hearing, this kind of a stuck transmitter is a known failure mode for the Itron built automatic meter reading or AMR ERT units that were in use in 2010. As he further testified, failure of the electronic transmitter does not suggest that the mechanical register part of the unit also failed. Accordingly, when WRB received the results of this meter work, the reading shown on the dial was deemed to be a correct reading of actual usage between 2010 and 2017, and was used to assess a back bill on actual usage on the bill dated November 16th, 2017. That is the city's position and the city's reading of the testimony and evidence submitted at the prior hearing.
Okay, thank you very much. Does the petitioner also have a summary like that would refresh memories for the board members?
I do. The summary is as follows. It's my position that the meter was defective. It is spelled out in my brief in support of appeal. I raised significant issues regarding the consistency, accuracy, reliability of the equipment based on the amount of time it took to rectify the issue. And as a matter of fact, actually a series of things not done in terms of checks and balances. I raised several issues that are of constitutional import, including but not limited to that when the equipment was taken back to the shop and the WRB determined that there was a back bill in question, the city failed to preserve the equipment for review, testing. I notice and will note for the record that there is a meter assembly which is kept in the other room as a matter of routine. And it would have been of no consequence to keep that equipment around to allow questioning of it. I raised issues specifically in terms of the accuracy, in as much as there was never any audit done of the equipment. I raised an issue with respect to a potential for backflow. That was not credibly ruled out. I also raised in my documents that there was a significant history of failure of equipment, and to merely assume that everything was working properly is an error. And I expect that in this hearing, there will be evidence which will indicate that in accordance with the court's directive, that there was a check and balance was not done with regard to the installation. And therefore, that affects the first part of the order in terms of the proper or improper installation of the equipment. That is what I would have as my summary. And I believe I will be relatively brief because it is a narrow scope. I will say, in light of the prior testimony, which was that Mr. Paul, he indicated that he was not present at any point when the field service representative serviced the resident 6141 Carpenter Street. To the extent that the city has indicated there's supposed to be some extensive or some extensive review of the photographs, I would submit and ask for, I would submit that the supervisor, Mr. Paul, he lacks the appropriate foundation to speak on what may or may not have occurred with respect to how these photographs were taken. I may be a little bit premature, but I'm actually going by based on what the city said. And at the appropriate time, I will raise the objection and I will ask to colloquy as to foundation. I understand these proceedings are relaxed. However, this body is still obligated to take competent testimony.
You know, Mr. Martin, we don't need you to tell us our job, quite honestly. If you have evidence that you're ready to put on, now would probably be a good time.
Very well.
One second. I did notice, Mr. Horton, you mentioned something in the other room. Were you referring to our office's other room?
Yes, yes. Yes, I was just saying I was directed to go there. So when I came here, I was trying to get organized, and therefore I didn't hear the sequestration order and from whom it came. And I was just trying to get organized here. So that's why I was a little late, and also I didn't hear. So that was what I was referring to.
Oh, okay. No, because I thought you had said something about equipment in the other room. I just wanted to understand where that was coming from.
Oh, yes, there is equipment in the other room. Yes, yes, I did say that.
He was referring to the sample meter assembly in the hearing room.
Yeah, okay.
Right.
No, I just wanted to make sure. And does anybody want me to bring that into this room, into the room you're in, Mr. Horton? Because you're referring to it. I just want to make sure we're.
Yeah, I mean, you could bring it in, but it came up at the last hearing because there was a suggestion somehow that that would be overly burdensome, and therefore that's why it was not preserved, even though there was testimony that it was preserved at some point. And that obviously goes to my spoliation argument.
If I might, Melissa, so two things. I would suggest that in the interest of flow, that I be allowed to do directs of Mr. Parker and if necessary, Ms. Smith, and then Mr. Horton would be permitted to cross-examine under normal rules. And then a second point, and this, I'm not going to belabor it, but the spoliation argument, to my recollection, was not argued on appeal and is therefore not appropriate to be considered at this time. But I'm not going to belabor the point. I'm just making it and preserving that argument for appeal. If I may, Ms. Andre, proceed to direct Mr. Parker.
I'm just gonna defer to my board about how they want to hear the evidence. Sorry.
Yeah, I'm pretty sure the petitioner has to give his opening statements. I understand he was just giving us a summary of why we're here today. So he needs to do his opening, then the city's representative can provide his opening. Let's see if the petitioner has any evidence to support what we're reviewing on remand today, and then it goes back to the city.
One other point, if we could just have the numbers for the record, that was not testified to yet.
Thank you.
So where does that leave us in terms of who's next?
Well, we need the numbers first,
The numbers.
Okay,
and then it'll go back to the petitioner for him to provide his any new evidence or anything.
okay, thank you. Thank you very much for helping me out of the morass there. If the city can provide the numbers for the record, please.
Chanel, you're on mute.
Okay, the water customers disputing the dispute period for September 20th, 2012 through October 30th, 2017. Principal amount $7,935.43. Penalty amount $181.41. Lien amount $111.45, bringing the total disputed amount to $8,228.29.
Thank you, Chanel.
And I'm sorry for clarification in terms of the muting. I noticed she heard you. I'm requesting that the muting is not with respect to someone's ability to speak, but someone's ability to hear. So who's controlling that? Is there an IT person that's doing that?
That is me.
No,
Okay, so
No, we're not doing that. Thank you for your request, but I think that
so
I defer to my other board members if they think that that's necessary, but that's not a general procedure that we follow.
but that's the whole idea of sequestration, that no other
These
party
hearings
will
are
hear.
public, sir. I'm sorry.
I
to
can't-
interject,
I
but
can't
the
hear you.
hearings are public.
I understand the public nature of the hearing, but the integrity of testifying, I am entitled to have integrity, or know that there's integrity, and one witness is not listening to the testimony of another and therefore potentially conforming his or her testimony to that.
So just so we're clear, let me just make sure I understand what the request is. He wants you to put anyone that's not speaking in a separate room in Zoom. That's what he's asking.
Well,
No, that's what you're asking for.
Yes, I believe that would be appropriate so that one witness is not conforming his or her testimony to what they hear from the other. That's basic.
Does the
Court
board have an
procedure.
opinion about that? Because that's not what I am.
The remand, and they've already heard each other in the prior hearing. Everyone's got a transcript. Everyone has seen the appeal. Everyone has heard what everyone has had to say in some of these matters.
Okay,
And with the exception of some of our business cases, and there are a few other items from time to time, we do not normally sequester people from hearing what the other witnesses or participants are saying. I don't know whether I'm stating that correctly, but basically the only ones that we cut off so that no one else hears a case are the ones that are more secure in terms of business cases.
So just so for clarification, you do realize these are public hearings, right?
I understand, but
Okay, but hold on. So I'm just for hypothetical purposes, even if we put this person in another room, if they decide to say they want to come sit in that room with you right now, or to actually just pop back in here underneath another phone number, we can let them in because it's a public hearing. I'm just saying this for the exercise of what you're asking us to do. I'm not saying that I'm denying the request of what you're requesting. I'm just pointing out that it's a little bit futile, and this is why we don't do it. But Melissa, do you want to step to the back for us to make a determination on this and then come back here?
Yeah, perhaps the board could just talk about it really briefly, just to make sure.
Do we want to hear Mr. Seyfedin's
Oh, yes.
response?
I leave it to the discretion of the board.
Thank you.
Okay.
All right, if everyone can just hold tight, the board is just going to discuss what Mr. Horton's request. Nancy, everyone is back.
See, we're back, and are we finishing with the city, or have we finished that? We're back to the petitioner?
No,
Yeah.
we're granting the request to sequester witnesses that are not. going to be-
Okay. I'm skipping ahead instead of going back. My apologies.
So Mr. Dybowski and Mr. Parker, I'm going to put you both in in the waiting room. And then when you're called, I'll bring you back in. So just please stay by the phone so that way I can bring you back in and we can get right into it. Is that okay with Mr. Dybowski, Mr. Parker? Did you hear me?
Yes.
Yes.
Thank you. Mr. Horton,
yes, my apologies, yes,
Mr. Dybowski and Mr. Parker are both in the waiting room.
thank you.
If you would continue then, please.
Yes, with respect to, I'm sorry, for
No.
me to continue?
Yes, but I was going to say, and we would like you to focus on the facts of the case as you see them so that we can direct our attention on to those matters and specifically the things that were raised by the court that we should be addressing. The first of which is whether the water meter at issue was improperly installed. Do you have any evidence or any information, factual information that we can and should consider on that matter?
Affirmatively, no, but if I may, I wanted to focus in on the other part of the court's order, which,
We wanted to start at the beginning here of the things that the court asked us to take a look at. Which is why I'm identifying item number 1 of the issues presented by the court, which reads whether the water meter at issue was improperly installed. And we'd like to hear any factual evidence about that matter, anything that you have or know. And
If
I
I may.
see that Mr. Kareem has raised his hand.
Yes, if I may, I might suggest that, and I think Mr. Horton might even agree with this, that in terms of getting affirmative evidence on the record, it's better to have Mr. Parker testify and allow him to proceed by cross-examination, Mr. Horton to proceed by cross-examination, rather than asking Mr. Horton, who by his own admission is the property owner and not a plumber or a meter technician or anything of the kind, to testify affirmatively. Mr. Horton, would you be agreed with that, allowing me to direct Mr. Parker? And then you would, if to the extent that you want to make your point, it would be in opposition to Mr. Parker's testimony?
I would, thank you.
So just for clarification, the petitioner has the burden of proof. So you're stating for the record that you don't have any new evidence today that evidences that the water meter was improperly installed.
Well, actually, this is why I wanted to proceed to the end, because I have evidence. It's actually to correct the record, and it pertains to the second part of the court's order, where it directed the tax review board to either issue a new decision if different from the original, or supplement its prior findings of facts and conclusions of law. To that extent, I can offer new information.
Okay, so for clarification, you don't have anything beyond what you're going to get solicited on cross-examination that the water meter was improperly installed.
That's not correct.
Do you have anything today beyond that?
Yes, I do.
Okay, so what evidence do you have that says that the meter was improperly installed?
Yes, I would ask that the body take judicial notice of Philadelphia Water Department regulations number 401.1D, which defines a water meter as including the meter body, the register, and any associated hardware, equipment, and devices for remotely collecting meter data. That would include the ERT that has been discussed.
Could you speak into the mic, please?
I said that would include the ERT, the register, and everything. There was significant testimony previously that the meter was separate from all these other things, when their own rules and regulations say it's all encompassing. To that extent, there were certain findings of facts, conclusions of law that were made based on that false testimony. And so I would offer that one. Secondly, so I would ask that the board take judicial notice of that. I don't know if you all have a
Have you
copy.
provided a copy of that section of the regulations to the board prior to this hearing and opposing counsel?
I'm
Have
sorry.
you provided a copy of that to anybody? Or you're just telling us, you're just citing to it to give us and asking us to take judicial notice?
Well, I actually, in private discussions regarding the case, provided that particular section in reliance that basically I was going to be relying on that. But the law is the law. This body, to answer your question, my apologies. No. I have
Okay,
not.
that's all I'm asking. Okay,
Okay.
so you
My
have not,
apologies. My
no worries.
apologies.
Okay, thank you. So
If
just
the
read
board
that.
pleases.
Okay.
I have no objection to his citation of the
Okay, perfect.
of the
That's all
water
I'm asking for. Okay, thank you.
regulations. I have them up in. I'd actually want which subsection is that for my reference?
Subsection
I have
B.
it up on my computer. I just need.
Okay,
They're big.
thank
I
you.
need to find.
I
them.
just wanted to for continuity of the record. Okay, go ahead.
And my apologies. It's 401.1D.
401.1D.
Correct. I would also ask this body to take judicial notice of 401.2 subsection A. And that speaks to the city's obligation to test, maintain, repair, and replace meters so that they remain operational. There was a finding of fact that they did not, I'm sorry, the city did not breach their obligation with that, in respect to that. And I honestly, well, I'm asking that the body take judicial notice of that.
Okay, so a finding of fact that the city did breach or did not breach?
Did breach. No, well, I'm
Okay.
not.
And what was the evidence of that?
If I might, I think this is closer to legal argument, which is fine, and it's appropriate to take at this stage.
I'm sorry to interject. I personally suggest that Mr. Safedin's suggestion that we hear testimony regarding this meter, regarding how it was installed, perhaps that could clear up a lot of things, and Mr. Horton can cross-examine Mr. Parker. I just think we need some sort of evidence to come into the record to then ask these questions.
If I may, with all due respect,
Sure.
judicial notice is a recognized form of evidence. To the extent that the court directed this body to potentially issue a new order, augment its findings of fact and conclusions of law, it is appropriate. I am only proceeding at this matter because Ms. Ward, in her questioning, asked me if I had affirmative evidence other than something I might offer on cross-examination. I certainly would feel uncomfortable cross-examining Mr. Paul on the law, but this body has that right and obligation respectfully, once I submit the appropriate information, for them to make a judicial finding of fact. And that's all I'm trying to do right now.
That's fine. Is there any other things you want the board to take judicial notice of?
I mean, I didn't get a ruling, but so I don't know, but that's what I would like the board to take judicial notice of. I would also like the board to take judicial notice of.
Mr. Horton, we recognize that the city's regulations are in existence and valid and need to be upheld. If that's what you're asking, we recognize that. What we're looking for, though, and maybe that'll come out in other testimony, is the facts supporting the enforcement of those regulations.
Okay, and my apologies. I'm assuming everyone had read the prior notes of testimony. My apologies. If I can only have the opportunity to revisit it at the end, I can tie it all in. But these things that I'm bringing up now, they're only being brought up because they came up in the prior hearing, and this is only a continuation of it. I had no idea that the composition of the board would change, et cetera. So that's all I'm trying to do right now. But as long as
What you're telling us is that you're willing to rely on whatever was entered into the record at the prior hearing, and that you have nothing additional in order to add to the record for us in looking at the remand order from the court, that you have nothing to add.
No, I am not saying, I am saying that what I am offering you now affirmatively coming from me is I'm requesting judicial notice of the law, which has bearing on the facts that came out during the prior hearing, as well as the facts that are likely going to come out now.
Well, I will tell you that we can take judicial notice of the regulations and the law. That does not, however, come with an assurance that we agree with your interpretation of how the facts fit the law.
I understand, but
Okay, then yes. I mean, Dominique, of course, we would take judicial notice that there are water revenue regulations that we need to be guided by.
Thank you. If the board pleases, I'm just interjecting right now to say that I intend to respond to Mr. Horton's statements about the regulations, but after testimony is taken from Mr. Parker and from Ms. Smith if necessary.
Okay, thank you. So we have the judicial notice, that is the evidence that the petitioner has provided at this point. Is there anything else you would like us to hear from you before we turn it to the city?
I have a couple of more, as long as I definitely agree with council's manner to proceed. I think it's the most efficient.
Okay,
If I could, if I can just, right, if it does not come up at the appropriate time with this particular witness or any of the city's witnesses, I would just simply ask if I can conclude my request for judicial notice at the
okay.
end.
So you want to preserve your right in order to raise anything that does not come up on cross-examination
Yes.
with judicial notices. That's fine.
Yes. Thank
Okay. City, your
Thank
witness,
you.
which one?
It should be
Thank
Mr.
you,
Parker.
Dominic.
Mr. Parker? Okay.
I thought we were turning to the city.
Yes,
Hey,
you
yes.
just called Mr. Parker. I'm putting him in the room.
Oh, my apologies.
It's okay.
Hi, Paul.
Hey, what's going on?
Okay.
Mr. Parker, please remember you've been previously sworn.
Okay, thank you.
All right. So, Mr. Parker, if the board pleases, because again, it's been over 2 years, and certain people, are new to this, I would ask the board's leave to briefly ask a few questions that might be reflected in the prior record, just to reorient the board as to who Mr. Parker is and why he testified. Mr. Parker, you testified at the last hearing on December 15th, 2020, that you were employed as a supervisor for the Philadelphia Water Department meter shop. Is that still correct information?
Yes, sir.
For reference, how long have you been with the meter shop?
Going on 10 years. It'll be 10 years, August.
And as part of that job, the jobs that you've had at the meter shop, you familiar with the record keeping system or systems that the meter shop uses to track meter work?
Yes.
And for reference, what is the system called?
Slinky.
Okay. And as part of your job, does Slinky have any other names, just to be clear?
Service Link. Service
you.
Link.
Okay. As part of your job, are you familiar with how residential water meters in Philadelphia record and transmit water usage data to PWD?
Yes.
As part of your job, are you familiar with the policies and procedures that the meter shop technicians must follow when they install or service water meters?
Yes.
Turning to the case at hand, you testified in the proceeding in December 2020 that you were there as the former supervisor of field service representative number 977, who, according to meter shop records, performed an ERT change at 6141 Carpenter Street on October 30th, 2017, and that you testified because Representative 977 was unavailable to testify because he no longer worked for the water department. Has FSR 977 returned to the meter shop since the last hearing?
No.
Okay. And for clarity, again, and if the board thinks I'm running a little long on this, please feel free to cut me off. According to meter shop records, what kind of ERT was in the property before the ERT change?
M25.
Okay. And according to meter shop records, which company manufactured that ERT?
Itron.
Is Itron still the supplier for PWD residential ERTs today?
No. No, they're no longer the
about-
supplier.
About when did they stop being the supplier?
Around I think it's 3 years now. 3
Okay.
years.
Approximately 2020 then?
Yep. Around
Okay.
2020.
Okay. And just to segue into the actual questions you have today, according to meter shop records, why was the ERT changed on October 30th, 2017?
It was sending the same reads over and over again.
Okay. To refresh the board, in your experience, your 10 years of experience as a stuck transmitter, a known way in which this kind of ERT fails?
Yes.
Okay. To refresh the board, when a transmitter is stuck at its initial reading, does that affect the reading on the mechanical dial in any way?
No.
Okay.
Uh,
I'm going to share my screen.
Okay.
Need to actually open the item first. Pardon me. Full of Pete.
Is there a problem?
Yeah, my computer is being very slow. I am finding the relevant, the item that
Okay,
I'm going to
I
be-
just thought maybe something had happened.
No, it's just annoyance. Generalized annoyance. Okay, I'm getting close, I think. Okay. Okay. I'm going to share
Is there some,
a. It's not showing.
is there something else you can present that would,
No. It's. Why isn't it? Curiouser and curious. Let me try this again. Here we go. Okay. What I'm sharing now is a PDF document, which, as you can see here, consists of 2 photographs and was previously labeled as P2.
I'm seeing a meter, is that what I should be looking at?
Yes. Now, Mr. Parker, have you had a chance to review these 2 photos?
Yes.
Drawing your attention to the second one, can you explain why the second one might appear to be reversed?
Objection, foundation.
If I may, matter, this is not,
Well, hold on, the objection was,
Let the city finish.
if
well,
I,
we
if I
actually
may,
have, we have to rule on the action. Go ahead.
Well, I just wanted to put my basis for the objection, no foundation, on the
We're-
record.
These were entered prior. These have already been entered into evidence, correct, Mr. Safedine?
yes, they are. I am trying to explain something intrinsic to the evidence, which I think the particular fact which I am trying to evince is, or should be, apparent to any competent individual.
The numbers,
Which is that the writing, all the writing on this, in this photograph, appears to be reversed. And I am asking if Mr. Parker can suggest a reason why that might be the case.
And I would object to that, no foundation. He was not present. He's being asked to speculate, and there's no foundation for that. He's not a forensic, photographic, or imagery expert. He simply isn't.
Well, the city has already said that Mr. Parker is an expert, though.
Not in this context. He's an expert in meter stuff, but Mr.
Well, this is meter
Silver-
stuff from the board's perspective.
Well,
Yeah,
if I might present some clarification on the reason I'm asking Mr. Parker to testify as to possible reasons that this might be that this might appear to be reversed or mirrored, in that he is an expert on meter shop policies, which could present a plausible explanation for why there might be a mirrored image in city records.
Thank you. We're gonna note the objection for the record. Thank you, but we're gonna move on. Go ahead.
Excuse me, I have a different objection now. I have a different objection.
Please
ask-
state your objection.
We would,
You know, this particular appeal was dismissed erroneously by this board. So for 9 months, there was no action on this case. And I had to file a writ of mandamus. And this has been hanging over my head for years. Now, this is on remand, not because I made a mistake, but because the board did something that they weren't supposed to do.
Okay, so I
So
think,
I would appreciate.
we'd like
well,
to
hold on,
hear,
hold on, let's take a moment. Let's take a moment. First and foremost, you are making an objection regarding the city's witness and his level of what kind of expert he is, correct? So we're gonna overrule that objection because this is pertaining to meters. You now have a second speaking objection. What is that?
Asked and answered. This individual was asked the last time if he had an explanation for this, and he said no. And that's in notes of testimony. Beg the board to indulge me. Notes and testimony pages 151 to 152, line 16 to 25, and going into line 1 on page 152.
and what does it say?
Question. Now, you don't have any firsthand knowledge as to why this picture purports to have a register with reverse numbers, do you? And may the record reflect, I want this marked as, I guess, plaintiff, I'm sorry, petitioner's number 2. Do you have any reason, you don't have any firsthand knowledge of why this is depicting an upside down backwards register, do you? Mr. Parker, no. So 2 years later, he's got a reason?
He may have researched it. If he has additional information, I, for one, would like to hear it. I don't know about the other board members.
May I have a ruling on my objection then?
So, 1 second, can the court reporter read back the question that the city was asking Mr. Parker?
That the city was asking Mr. Parker before the objections?
Yes.
Okay. Yes, I can. Give me a minute.
Thank you.
So. Are we going to have him?
No, the court reporter, we're waiting for her to read back into the record. What was the question that?
Oh, okay, I thought she had
To
read.
see if it was asked and answered.
Yeah, and I'm not writing in real time, so it'll
that's-
take me a minute. I don't know if you want the attorney to just repeat the question. It might be quicker.
If I might actually rephrase the question, just to address the issue. Mr. Parker, can
Yes.
you suggest an explanation why a photograph in Slinky might be reversed, might show reversed numbers?
Same
Depending
objection.
on,
Mr. Parker?
Say that again?
depending on it. Depending on the location on the meter, it's possible the tech used the mirror.
Okay,
That's common practice for us. If your meter is located somewhere where we can't just take a picture of it, if we gotta reach around something, if it's behind something, we may have to use a mirror sometime.
okay. And does meter shop policy authorize this or procedure?
Yes,
Thank you. Is there anything given that taking this as a mirror image, is there anything else in this photograph which would suggest that the meter assembly in the property was installed incorrectly?
no,
And for a final point, if a meter is installed backwards, does it register any usage whatsoever?
no.
Thank you.
Do you have any additional questions for your witness, City?
One final one. If there is, actually, no, actually, no.
Petitioner, is your witness on cross?
Mr. Horton can
Thank you.
ask what he likes. I'll put myself on mute. Although, Mr. Horton, do you want me to keep this photograph up or should I stop sharing?
At this juncture, you can keep it up. Thank you, sir.
No problem. I'll put myself on mute.
Mr. Parker. Good afternoon, sir. Can you hear me?
Yes, good afternoon.
Okay. Do you have any electronic record of any kind, including in your Slinky, that a mirror was used by Field Service Representative 977 during his install or reinstall on the date in question, 7/31/10?
No,
And that includes your Slinky and any other electronic record.
no,
How about your meter replacement card? Does that indicate a mirror was used during the install or reinstall on 7/31/2010?
no,
And you were not present during the install or reinstall on 7/31/2010? Is that correct?
yes,
You've never been to the basement of that property, correct?
no,
If I might provide a small factual correction for Mr. Horton, the meter change in question was 10/31/17. The 7/31/10, this is a photograph of 10/30/17. 10/31 or 7/31/10 was not, there was no photos of that as admitted.
You're correct.
It's a minor point. I just
No,
wanted.
no, it's significant for the record. I appreciate it, counsel. Thank you very much. So, Mr. Parker, with respect to that corrected date, 10/31/17, do your answers remain the same, sir?
yes,
And my apologies, I misspoke. It's 10/30/17. I apologize again.
Again, Mr. Parker, with respect to that corrected date. does
yes, my answer stay the same.
Thank you. And I believe you told us before the interjection that you've never been to the basement of that property, 6141 Carpenter Street?
No, sir.
Is there any written record, electronic or otherwise, that meter that was in that property was not easily accessible?
No, sir.
And as a supervisor, I believe you said you're a supervisor, you are familiar with the department, with the Philadelphia Water Department regulations, are you not?
Yes,
Sir, in fact, if a meter is not easily accessible, isn't it true that the department can make a homeowner move his plumbing?
Yes, it is true.
Thank
That
you.
is true.
And
But
do
as
you
a
have
service
any-
to customers,
Sir,
can you let
You've
me
answered my
answer?
question. You've answered my question.
Well, I would like to complete my answer. I didn't completely answer. You asked, I'm gonna answer your question. We could give the customer an obstruction, but as a service to customers, when we can just reach and get it, we'll do that. That's to save the customer money, to not
Okay.
potentially make them have to hire a plumber and move plumbing. If we can do that, we'll do that for them, if it's that simple to do.
Okay,
So that's why we do that.
but my question to you is, you have no record, electronic or otherwise, that meter was inaccessible or not easily
No.
accessible, correct? Okay,
No,
and you previously testified in this matter, correct?
yes,
And you were asked about the meter depicted in petitioner's number 2, correct?
yes,
At that time, you had no explanation as to why that register, meter body appeared as it did, correct?
no, that's not correct.
Okay, let
Going
me
back,
ask you this. Hold on.
once again, I would like to answer your question once
My
again. Your
question was-
question towards me was based on firsthand knowledge, as you stated when you repeated it again just now.
Okay,
You said
so
your whole line of questioning at that time was whether I was in the property. That's why I said no.
I'm sorry, sir, I couldn't hear you. Go
Your
ahead.
line of questioning at that time was whether I have firsthand knowledge.
Okay, and let me
No,
ask you,
I don't. I
okay,
have knowledge from the records and from us doing this repeatedly.
and let me ask you this.
That's why I answered no.
Okay, and so let me ask you this. Previously, without firsthand knowledge, you testified that the field service representative 977 filled out his service card in the basement. Isn't that correct?
Yes, sir.
Okay. And on my cross-examination, you admitted that it was possible he could have filled it out in his vehicle at lunch. Isn't that correct?
Yes, sir.
Okay, so you were speculating then, correct, that he filled it out in the basement?
It's not
Objection.
speculation, it's the procedure of the
Sir,
job.
my question is, without firsthand knowledge, you were speculating that he filled it out in the basement, correct?
Objection, mischaracterization of the prior test, you're putting a spin on it. I argued at the time that it wasn't speculation, it was habit evidence, because he knew the FSR personally and could testify to his adherence to policy.
Mr. Seinfeld is correct. That was his argument. However, that was not the testimony.
Do you have a reference in the record regarding that testimony?
I do.
Okay, so you are going to go through the process of impeaching this witness?
Yes.
Okay, go ahead. And for the record, the asked and answered objection that was earlier would have been sustained, but counsel subsequently after that asked the question a different way. But go ahead, proceed forward with your.
If I might ask for a brief procedural recess to get some water.
Sure.
Thank you. I'll mute. Okay, I'm back.
You can proceed forward with
Thank
the
you.
impeachment. Thank you.
Thank you very much. May I have a moment to find it in the notes? It is marked. I just have to find it. Thank you.
Who is ready to speak at this point? Is it with the petitioner or is it with the city?
As a petitioner, he's impeaching the witness. He's looking for the citation in order to impeach him.
Okay, I thought so, but I wasn't 100% sure. If you can't find what you're looking for right now, can you move on to another issue?
Sure, I will come back to that. So, Mr. Paul, with respect to your testimony that there's policy that individuals use mirrors when something is inaccessible, you would agree that you, as you said here today, wanted the ability to complete your answer. You would agree that you volunteered in no way to complete your answer as you're testifying here today, correct?
I understand what you're saying, sir.
Okay. Previously, when you testified, strike that. Today, you're telling me the reason you answered no was because I asked if you had any firsthand knowledge as to why the meter appeared as it did in petitioner's number 2, correct?
Correct.
Okay. As you have done a couple of times here today, where you volunteered to complete your answer, you did no such thing back on December 15th of 2020 when you previously testified, correct?
Correct.
Okay. Now, with respect to, let me ask you this. Does plaintiffs 2, the bottom pick, does that show a mirror handle, mirror frame, the hand, or even a finger of what might be Field Service Representative 977?
No.
Okay. And let me ask you this, the very top of the picture, I'm sorry, the very top pick
Thank you.
of petitioner's number 2, you can actually see the face of the register, correct?
Correct.
Okay, and I'm not sure.
I'm sorry, Kareem, can you put the pictures? I actually can't see the pictures.
It should be showing the top picture right now.
Let's see.
Oh, okay, well, my apologies. Could you actually show him the bottom picture and I can re-ask my questions?
Okay, so here's the bottom picture. The mirrored one. And I'm using mirrored not in the sense it was taken in the mirror, but in the sense that it is a mirror image
I'm gonna
for whatever reason.
I'm gonna object to that. Okay.
I still can't. I
What
can't
is
see
your
it. But
objection?
okay.
You can't see it?
No. I
Mr.
just
Paul,
see,
could-
just see the
Mr. Paul,
gallery.
Mr. Paul, could you?
Okay, I'm gonna
speak when
stop sharing and share again.
Mr. Paul, could you see it when you were testifying earlier?
Yes,
But
Okay, there
Yes, I
must have
could.
been some technical glitch.
so I'm gonna,
there we go.
Okay,
Okay,
That-
now, go ahead. I'm sorry.
is that the bottom or the top?
this is the bottom.
Okay. Mr. Paul,
Yes,
anywhere in the bottom of petitions number 2, do you see the handle of a mirror?
no,
No,
Do you see the frame that might encompass a mirror?
no,
Do you see a hand or even a finger that might be holding a mirror?
no,
Okay, now, I want to direct your attention to the top of petitioners number 2. Please take a look at that, sir. Same question. Do you see a handle of a mirror?
no,
Do you see a frame of a mirror?
no,
Do you see a hand or finger of someone who might be holding a mirror?
no,
Okay. And you, and in the top picture that we're looking at now, I don't know the definition or the resolution that you have, but you can see the face of the doll, correct?
yes,
And you see the numbers that I'm looking at the top?
No.
That says,
yeah,
you can see it, 725 OC, looks like B, then it says cubic feet. You can see that, can't you?
right.
Excuse
Okay.
me, what
So-
exactly are we looking at on this document? I don't see what is being referenced.
The-
Are we talking about the same image that's on the screen?
Yes, we are. My apologies. It is the register
Okay,
portion of the meter.
okay.
Okay. So you would agree, sir, you can see the top as well as you agree you can see the top, correct?
Yes,
Okay. And those numbers do not appear to be reversed in any way, right?
no,
Okay. And you don't have any indication that that was placed in a way different than how the one that was taken out was, do you?
no,
So for
And let me
reference,
ask you,
is this top picture the new meter and the bottom one is the old meter?
correct.
Okay, thank you. Keep going.
And Mr. Paul, just for the
Yes.
record,
yes,
I'm sorry, at the top, you can also see the manufacturer on that register, correct?
yes,
Okay. Got no problems reading that. Let me ask you this. You've never been qualified as an expert in photography or, I'm sorry, forensic photography or imagery, correct?
no,
Do you have any kind of background in forensic photography or imagery?
no,
Now, I believe you told us that you are familiar with department regulations, right?
yes,
Okay. And you agree that per your regs, that a meter includes the meter body, the register, any associated hardware, equipment, and devices for remotely collecting data, correct?
Objection. That's a legal question to which a fact witness is not qualified to answer.
I would disagree respectfully. One, he said he's familiar with the regulations. I am reading from the regulations. Certainly, if he can speculate as to what took place at a location that he physically wasn't there, he
Okay.
can certainly testify as
But-
to regulations and law that govern his job.
So let's parse that out. He is not necessarily speculating to what happened. He's relying on the business records and the practices and procedures of his office. That's different than what you're saying here. I'm just pointing that out for the record. the speculation that you're relying on is trying to assert that he has no idea this is just coming out of the sky. He's actually basing this, as the city has already had him testify to, the procedures of his actual office and how they actually conduct business records and things like that. Now, regarding this definition from the regulations, he did just testify that he is familiar with the regulations. So petitioner asking the question if he's familiar with that is a valid question. So that means your objection is going to be overruled. Please proceed forward.
Thank you.
Sir, my question is, you agree that per the regs, the meter includes the meter body, register, any associated hardware, equipment, and devices for remotely collecting data, correct?
Yes,
And associated hardware, equipment, and devices for remotely collecting data, that would include the ERT, correct?
yes,
And by the way, you do know that per the regs, the department allows an unmetered service connection under certain circumstances, correct?
I'm not familiar with what
You're
you're
not
speaking
familiar
of,
with
sir.
that? Okay.
Yeah,
Okay, fine. I'll ask,
Yeah,
I will ask that the board take judicial notice of regulation 401.1B, and I will reserve that for my argument. Now, sir, Mr. Paul,
by the way, one last thing. Do you still need the photos?
I don't believe I do at this point. Thank you.
Okay, I'm gonna stop sharing then.
All right, thank you.
Thank you.
Sir, Mr. Paul, you agree per the regs that new meters shall be tested before installation, correct?
yes,
Objection, relevance.
Dane, next question.
May I be heard on that? Regarding the court's directive, this speaks to the installation.
If I may further elaborate, the issue here is not, the issue here doesn't have, the issue in this case is about the meter that was found in the property and removed on, that was found in the property and removed, or excuse me, the ERT that was removed on October 30th, 2017. Whether or not it was tested before installation in 2010, I don't see the relevance here.
Okay. I'm sorry, counsel, you done?
That's it.
Okay, thank you. The relevance is clearly whether per the court's order, this was installed properly. There's testimony in the prior hearing that the ERT never changed. The reading was the same on day one as it was when they took it out in 2017. So it is highly relevant.
But you're questioning whether the meter that was installed was tested prior to being installed. That's what you're asking about, right?
No,
That was your question.
no. That's
That was your question. That was your question. See, that's what I'm trying to point out. Your question was that. And that's why I sustained the objection. I understand what you're saying is regarding the court order, but you just asked Mr. Parker if the meter was tested before it was installed. So that's what you asked. And so is that what you meant to ask, or you meant to ask something different?
Respectfully, I don't believe I asked that. I can ask it a different way. What I asked was a general statement, not with respect to that particular one. I asked in terms of what the policy was per new installation, not necessarily that one. I didn't ask that.
Okay, well, our issue is with that one, however, because we're trying to deal with what happened then and addressing the issues that were heard in court before.
Okay, so.
And that's what we should be surveying, not hypotheticals in other areas.
Okay, so I can't, so let me ask you this, Mr. Paul. You are aware of a policy that says you are to test every new meter before it's installed, right? Is that not a
Yes.
regulation, sir? Thank you.
The
And
meters are
the-
tested yes, before we
And
install them, yes.
in the case of a reinstallation of a meter, and we know from prior testimony, it's everything encompassing that meter, the register, the meter body, the earth.
I know.
In the
yeah,
case
I agree
of
with you.
the reinstallation of used equipment, that is also to be tested, correct?
Yes,
Okay, and these things are to be tested to confirm performance within industry standards, either before installation at the property or upon reinstallation, correct?
yes.
Now, you are aware that the earth did not move the day it was installed until, I'm sorry, you are aware that the reading on the earth, which is the meter, remained the same from 2010 to 2017, correct?
That's not what happened, sir.
Sir, did the earth change its reading from the day of installation until it was removed in 2017? Yes or no?
Yes,
Okay, what was the reading on the day it was installed?
I don't have it in front of me,
You don't have it in front of you?
in front of
If
me,
I
no.
might be
So-
permitted to have Mr.
Can
Parker
I
take a-
expand on that? Can I expand
Sir,
on
you've
it?
answered my
Lorraine?
question. You've answered my
I'm gonna
question.
answer your
You
question.
answered
I'm
my
gonna expand on
question.
it.
Paul, I
Go ahead.
can ask you questions on redirect. You don't have to.
So
Okay,
at this point, yes,
Let's hear from
I'm
the
sorry,
city
Madam Chair.
with some direct questions on this matter so we can get through some of this and verify what their position is. We can come back to you at a later point if we need to.
So Mr. Parker, you are aware that the relevant time frame here is from 7/31/2010 to 10/30/2017, correct? You are aware of that, correct?
I don't know the exact dates. Again, I don't have that in front of me.
Okay, so you don't have any electronic documents in front of you?
No.
Did you review your testimony?
Yes, I
before?
did.
Okay.
Yes, I did, but I don't have the documents in front of me.
Oh, okay. So, but is it your testimony at this moment that the reading on the earth changed from the time it was installed until the time it was removed? Is that your testimony right
I'm
now?
going to object to that question as to the form because it's ambiguous. Because as established in his prior testimony, there are two readings from an ERT: the visual reading on the dial and the electronic reading from the transmitter. And
Right.
it's unclear what your question is pertaining to. That's the city's objection to this. I leave it to the board's discretion.
I will rephrase it. Sir, I am not talking about the register at all.
Okay.
Okay, what I am talking about is the electronic radio transmitter.
Okay.
Okay? Is it your testimony here at this time that the reading on the electronic radio transmitter changed from 2017 when it was installed
You mean
until it
2010?
was removed in 2017?
Okay.
Can I say something?
Sir, please answer my question.
You're not asking the question correctly.
Sir, my question to you,
Mr. Parker, on redirect, the city will be able to clarify any,
I understand. I
but are
understand,
you
but I
trying to
can't
say
answer.
so you're trying to say you're unable to answer the question because the
Okay.
question is answered improperly? So he's not able to
Exactly.
answer your question as you have given it to him. Can you please
Exactly.
rephrase your question
there's
or
no
move on?
Can we try to move on to something other than rehashing and rehashing the same pieces?
Sir, did the reading change on the ERT from 2017, 7/31, 2010 until it was removed in 2017? Did it change?
Mr. Parker, if you can't answer the question, just say you can't answer the question.
I can't answer the question.
Move
Can we
on.
move- Next question, please.
Sir, you would agree that, right, I believe you told us earlier, when you testified back in December of 2020, that this meter had never been audited, correct?
I don't remember saying that. I don't remember, sir.
You don't remember? Okay. Do you have the notes of testimony in front of you?
Not in front of me.
But you did review your testimony before testifying today, right?
Yes, yes, but I don't remember offhand.
Oh, you don't remember offhand? Okay.
Yes.
Just for clarification, is this question going to whether the meter was actually installed properly or not?
It is, yeah.
Okay.
So as you stand here today, you have no answer for whether the meter was ever audited, correct?
When you say ever, what do you mean ever, or after it was replaced, or your questions are not,
Well,
it's
okay.
hard for me to understand.
I'll do it this way.
Mr. Parker, if you can't answer the question, just say you can't answer the
Okay,
question.
Okay,
okay,
so
thank you. I'm sorry.
when the meter that is the subject of this litigation was installed, you have no record, electronic or otherwise, that it was ever audited, correct?
No,
Object.
No, wait a minute, is that no, I'm not correct, or no, it was not audited?
you say,
Or
do
no, you don't
I
have the
have,
records.
I don't have a record. No, I don't. I
Okay.
don't, no.
All right, thank you. And you
You
haven't,
said, do I?
you haven't reviewed any record pursuant to this case that would show that it was audited at any point, have you?
It was audited
When?
once we replaced it.
Now, you testified back in December 2015, correct?
Right.
Okay. You never,
Objection.
you,
The hearing was December 15th of 2020.
of 2020, my apologies. December 15th of 2020, you never mentioned that that meter was audited, correct?
I'm not trying to
I
cut
was-
off your case in chief, but I feel like he's already said multiple times the last few questions, he cannot recollect these responses that you're looking for. And I query this. If there are points in the testimony that you want to elicit that were already testified to, if you want to prepare them, provide them or reference them at a later time, that'd be great. But at this point, you're going to get the response you're looking for because it doesn't sound like he can recollect these specifics from his testimony. I'm just giving this as a baseline. I don't know if any more of your questions are going to go directly to that, but if they are, I don't believe Mr. Parker is going to provide the responses, be able to answer those questions at this point in time.
In addition, if I can add, if the testimony's already been elicited and you want to make an argument later regarding that testimony, I don't know that we need to have him repeat the same testimony that he's already.
Over and over again.
Well, I'll say this, the argument, there were certain things that were not included in the notes of testimony the last time. And so my concern is if I make an argument, there will be no record of it. So I would.
You saying that our notes of testimony are incomplete?
I'm saying that there was yes, I am. I'm saying that there was an opening statement that was made by myself as well as opposing counsel. And my review of this says that there were some things that were not included in it. So what I'm trying to do as briefly as possible is hit the salient points. Some of them may be redundant to some who were here, but others who were not, it's new to them. So that's all I'm trying to do.
Well, it seems like it's gotten very repetitive, so if we could just move
Yes.
on and
And-
be as concise as possible, that would be
we-
very.
And we should have an end to this. I know for myself, I have a problem with something backing up to this, and I have a hard stop at 4 o'clock, and we're almost getting to that. And I would like to be able to wrap up today, but we can't if we keep going back over and over and over again. So can we move on, or do we need to have anything from the city to be able to do it? I'm just not sure where we can go, because I feel like we haven't accomplished anything.
Well,
Board pleases, I have 4 redirect questions for Mr. Parker.
sorry.
That's all.
I'm sorry.
But that's timing of that is up to the board and Mr. Horton.
I'm sorry. I have a question or two.
Okay, so now these questions that you're asking though, are they qualifying questions regarding the notes of testimony, or are they going to be new information questions, or are they just a rehashing of what was already testified?
I have no idea what his answer is going to be today. He's already testified differently than he testified before. He's got this memory loss now, even though he reviewed his notes of testimony
That's
before
okay.
testifying.
Can you just ask your questions?
Fine, go ahead.
Mr. Paul, you testified previously that there was no backflow sensor. Remember that, sir?
No, there was no backflow sensor. We
Okay,
know that. I
remember
know
that. Okay, all right. And you are aware that your regulations provide that when setting up new plumbing, a homeowner must make sure that there is protection from public water supply from backflow from a property. You're aware of that, correct?
Yes.
Okay, so backflow is potentially a real issue, correct? It's recognized by your regulations.
I can't answer that question.
You can or you won't, sir.
I can't answer it.
You
I
can
can't
or you
answer it
won't, sir.
because
Okay, hold on
It's
now.
not-
He's already said he cannot answer the question. Please do not badger the witness. Continue with your questioning.
So I would just simply ask the board also take judicial notice of rule and regulation 401.7 relating to his testimony.
So noted.
So
What are your further questions?
no, I don't have any questions except
Fine. We're going to turn to Mr. Safedine. You've got 4 redirect,
3, actually, I think.
3? Okay.
They're
Yeah.
doing better.
So, Mr. Parker, are FSRs required under policy or procedures to note if their photo was taken with a mirror?
no,
Are FSRs required to note when an ERT was difficult to access, provided that they were ultimately actually able to access the ERT?
objection leading and argumentative.
Cross-examination allows for that.
He's suggesting the answer, Ms. Weiss.
We're with the city for testimony right now. Thank you.
And if I might briefly respond to the question, I'm asking about a very specific conditional situation.
Restate the question.
Okay. All right, Mr. Parker, if an FSR is actually able to access an ERT to service it, do they have to make any notation about it being hard to reach or anything of that kind?
no,
Okay. And do they customarily, irrespective of any requirement, make notations about a mirror or difficult ERT change?
no.
Okay. That concludes my redirect.
A brief recross. Mr. Paul, FSRs do note conditions that they find upon entering a property occasionally, correct?
Yes.
Thank you. Nothing further.
Any board members have any questions or issues?
No, but I assume that Mr. Savadine, you still have another witness?
Actually, we can rely on, unless the board wants a brief refresher on the billing, we can rely on what's in the notes of testimony.
So if
Ms.
that's,
Smith was merely here to answer any basis questions that the board might have and to recite the numbers.
all right, thank you, Ms. Smith. So are you saying that you're ready to wrap up?
Yeah, actually.
So can we do 2 brief closings? Nancy, I don't know how hard your stop is.
Well, I mean, I can maybe wiggle it a little bit, but I have someone I'm picking up that I have to, work my timing on, but I can go a little beyond
All
4.
right, so can we do 2 brief closings? And then we
And should we start with the city?
Thank you.
Or would it be better to go the other way? Start with the city? Are you agreeable to that?
I leave it to Mr. Horton, actually, if he wants to go first or second.
Okay,
I believe as the petitioner, it was pointed out, I have the burden of proof, which means I go first and last.
Proceed,
Very
Mr.
well.
Horton.
Thank you. If I can just go back to my reservation of affirmative information. I raised, with all due respect, I did raise my spoliation issue on appeal. I did it in writing. I did it at the last hearing. That's on notes of testimony, pages 146 and 147. Specifically raised it. I would ask this body to make specific findings and facts, conclusions of law with respect to the case that I cited and the elements. I also raised on appeal to the court an equal protection argument.
Mr. Horton, I'm sorry, I'm gonna have to stop you. The court was very clear about what we needed to do. They even gave us like an outline, 3 questions. I really think we should focus in on those things and let the court decide the larger issues of equal protection and so on. Please, if you can, and I said this in the beginning, can we focus on these 3 things that the Court of Common Pleas specifically asked the Tax Review Board to find? And you're right about the second portion, but those things were already brought up before the Court of Common Pleas, and the Common Pleas was specific about what we needed to do. So it is my job as the executive director to continue to direct the board to look at the issues that we have to address. Can you please address the 3 issues that were stated by the Court of Common Pleas?
Okay, I would ask for judicial notice of regulation 401.2 A1 and 2. And that speaks to the testing, new installation and reinstallation that was testified here to today. I would also argue that clearly the installation was improper. I can say that very confidently because the notes of testimony reveal that the reading on the ERT never changed from the day it was installed to the day it was removed. Therefore, testing as required by the regs obviously did not occur. So the installation was improper. With respect to whether the meter, if the impact of the improper installation, what impact, if any, did the improper installation have on the reading? With all due respect, it's unknown. Reason I can say confidently it's unknown is because 1, the register, meter body were never audited, irrespective of the convenient memory lapse here. The record will reveal that this matter was never audited, so we have no way of knowing the accuracy of it. Secondly, we know that there was a potential for backflow. It was never credibly ruled out, even though I brought these issues to the attention of this body previously, and I'm doing it now. I'm also bringing the fact that there's a history of malfunctioning equipment that the board is well aware of. To that extent, I would ask the board to recall the case of Casa Carib. In that case, I'm sorry, the full citation is Casa Carib 35 WRM ERZW 3283 10/22/18, the date, finding that the calibration issue caused by the Water Revenue Bureau with the reading from the meter had been removed, resulting in an unpaid balance of $52,662.37. The petition was granted there. That was wiped off completely.
We were also overturned by the court, the Commonwealth Court on that case, sir.
Okay, well, my point is that there's an equal protection argument. What was brought out was that that individual suffered a hardship. It was a nonprofit.
Mr. Horton, we don't want to re-argue that case. Please stick to.
Well,
your-
this is
We need to
argument.
stick with the case that's before us.
Okay, all right.
Mr. Horton, I do have a question. If in fact the board finds that the meter was improperly installed and that the improper installation had an effect on the meter reading, and then of course, I'm citing to the Court of Common Pleas directions, whether the Bureau is permitted to estimate water usage, and if so, the result of those estimates. How do you overcome section 401.6, where it says, when there's a defective meter, the Water Revenue Department shall determine the quantity of water used based on the usage for the periods prior?
Yes, I can answer that very clearly. One, as written, this is, and in regard to what didn't come out today and what didn't come out previously, it's unconstitutionally vague, non-specific, unclear, and I'll tell you why. The first part of that says usage periods prior to the meter becoming defective. Okay. Does that mean the equal amount of months that are in question? Does that mean the cubic feet that were used during the period of time in question? It's unclear, unspecific. Also, with respect to, I'm sorry, such becoming defective where such periods are not specified and where, my apologies. No, I have it. That's 06, I'm sorry.
I'm sorry,
I'm trying to answer your question.
Either way, Mr. Horton, I just think that's something that the board is going to be pondering. I also believe that the board will probably be asking for briefs. So it's something that I want to make sure is on the record in terms of thoughts of the board. Do you have anything else to say? Because again, we are pushing up to our time limit and our chair has to go. So can we have Mr. Saifuddin put a brief closing on the record?
Okay, if I could just put on the record my objection, I wasn't able to.
We've given you a lot of liberty on time, so make this the very last thing, please.
No, I'm willing to concede, but I'm objecting. Okay, but I'm willing to concede him the floor.
Okay.
Okay, thank you.
Mr. Kadim?
I appreciate the gesture, Mr. Horton. Again, for the board, this is a routine back bill on actual after discovery of a stuck transmitter. I can't tell you how many times we've had cases like this before you that I personally have presented. There is no suggestion based on the stuck transmitter that the register from which the back bill on which the back bill was based was affected by any failure of the transmitter. The definition of meter that Mr. Horton cites is regulatory and does not affect the physical reality that the meter assembly is made of three separate major parts, and that they largely fail separately. It is true that the city is responsible for maintaining water meters in residential properties, but maintenance requires the cooperation of the owner. In many cases, the city would not be aware of a problem unless the owner reached out. In this case, the city would not have been aware of any issue until contact was made by the property owner because the readings appeared to be actual. They weren't, but they appeared to be. And the owner's intervention would be needed to alert the city to the fact that the property was occupied and that a ERT change was warranted. Furthermore, as Mr. Parker testified, backflow, however risk might be to public water supplies, would not actually advance a residential meter assembly of this kind. And finally, I would like to briefly note that, as the board said, Casa Caribe was overturned, but even if it hadn't been, it dealt with a larger meter assembly and which has a different manner of operation. And that's all from the city.
Thank you.
Do we want to ask for briefs?
I'm sorry, what was that?
Should we have a briefing schedule
On
so that
what?
anything that was not put in the record? I'm asking my fellow board members.
Perhaps we could just go to the back very quickly.
I think that would be a good idea.
Let's go in the back, please.
If I could be heard on that, I indicated to the board that I had several impeaching matters. I was not given the time because of the answers being unexpectedly misremembered or not remembered. And I would like the opportunity to put before the board the impeaching matters that I have.
All right, we're going to go back and discuss it.
I'm just waiting for Nancy and Paula to get back in the room. Unfortunately, Dominique had to step out, but she agrees with the, it's not a decision, but it's holding it under advisement. Nancy?
Okay, fine. While we step back, the board decided that we wanted to take this matter under advisement for no more than a 5-page brief directly addressing the issues that were raised by the court in their remand to the board. So we want it focused on that. We want a brief from each side to that effect. And we want this within 30 days. If we have any further questions after we see those briefs, we'll get in touch with you to see whether we need to do anything going forward. But we think we have enough information at this point that with your briefs that direct the attention to the matters that are raised in the court's order to us. And you have that in the statement. There are 3 or 4 issues there that are being raised, and we want you to direct your attention to those matters, your interpretation and your presentation on each of those.
Okay.
Did I leave anything out in there from what we discussed?
No.
No, Nancy.
Thank you,
No,
Nancy.
you're okay.
Madam Chair, may I ask, is that 30 days subject to the availability of the transcript?
30 days, and your voice disappeared. What did you say? 30 days, what?
Is that 30 days subject to the availability of the transcript?
No, we
We
just
heard
wanted-
everything here, and we want
days
your
from today.
opinion and your information, so I'm not sure that it comes from the transcript, but any board member or Melissa want to add anything in there or interpret on that?
May I have the, I'm sorry.
30 days from today.
We think 30 days is ample time. We've considered a shorter period, so.
If the board pleases, may I just confirm my notes? So this matter is going to be held under advisement to allow the parties to file letter briefs. It will be
Correct.
limited, which will be limited to issues outlined in the remand order and limited to 5 pages. Is that double or single spaced?
We didn't address that.
Seriously.
You.
Whatever you deem best.
Thank you.
We
And
want to be
30 days.
able to read it succinctly. How's that?
Thank you. And 30 days, which would be Thursday, February 16th.
I
Correct.
hadn't looked at the calendar, but if that's 30 days out, we would go with that.
We could do Friday, the 17th. I think that's perfect.
Okay, if that makes it a little rounder and more attainable for people. Any other questions to come before us? And the board concurs on this. I think we can say that was a unanimous decision, and it included not only Paula, George, and I who are here, but also Dominique, who left a little early.
Yes.
And unless there's something else, I know I'm ready to step aside because I have someone who I'm picking up and I need to get moving. And so I thank you all and look forward to hearing from you with your briefs. And I'm
Thank you.
going to duck out. If anyone else has anything they want to converse on, be my guest.
Thank you so much.
Have a good day.
Thank you.
Have a good
Bye-bye.
day.
Bye.